and welcome to Crime and Court. My name is Heather, and this is another episode in my Wrongful Conviction Series, Innocence Lost. And as you can see by the thumbnail, we will be talking about these five gentlemen referred to as the Dixmoor Five. This is from Dixmoor, Illinois. Illinois, shout out. Woo woo. That's where I live. Um, Let me know in the comments where you guys live so you guys get a shout out. And then maybe I will do a crime in your town if you let me know, or a wrongfully convicted um, episode if you know of one in your town. All right, so as you can, the five men here are referred to as the Dixmoor Five. I'll tell you their names in a second. But we're going to be talking about their story and their wrongful conviction, but also a proposed bill in Illinois. Shout out. Woo, woo, a proposed bill in Illinois could help prevent false confessions, which is something that is prevalent in a lot of these cases that we've been covering on my Innocence Lost series, is that wrongful convictions can sometimes occur because someone gives a false confession. I've gone over on my channel the confession of Brendan Dassey and how things were very coerced from the law enforcement. So it can just knowing that law enforcement can use some tricky maneuvering to get their confession or get what they want from the individuals that they are talking to. It's just a little scary because they use the Reid technique, which I have talked about on my channel. It's in the Wrongful Conviction series. I'll put a link in this video if I remember. The Reid technique really implies that law enforcement can lie to you. They can tell you all sorts of things that aren't true. They can get in your face. They can, well, I mean, not that they can, but legally they can. As long as they're not hurting you, they can do that. Part of the problem too, though, with the Reid technique is they get deprived of food, water, bathroom breaks sometimes. You make the room really hot or uncomfortable. So there's a whole lot of ways in which um, the whole point of the Reid technique is to make the person feel uncomfortable. You corner them into the room and you block them from getting out the door and all sorts of things. So it makes people feel trapped. And these individuals were 14 at the time when they were brought in by the Dixmoor police. And Dixmoor is nearby where I used to live for a period of time in my life. I lived in an area around that Dixmoor, Flossmoor area. It's like southern suburbs of Chicago. All right. So, anyways, let me get this unmuted. Let's start with this video. I might interject a little bit here and there. Let me skip it to 1.25 here because we don't need it to go normal speed. And let me shrink myself and give you guys captions. Captions look like they're on. Okay, here we go.
Have you ever contemplated the terrifying reality of being convicted for a crime you didn't commit? Imagine the gut-wrenching fear of being handcuffed, the confusion as you're thrust into the labyrinth of the justice system, the despair as the gavel falls and you're sentenced to a lifetime in a cell. This is not a hypothetical scenario or a plot from a dark thriller. In America, this nightmare became the harsh reality for 5 innocent teenagers. Known as the Dixmoor Five, these young men were caught in a web of injustice that would rob them of their youth and change their lives forever. Jonathan Barr, James Harden, Robert Taylor, Robert Lee Veal, and Shane Sharp all were falsely accused of a heinous crime they didn't commit. Their names, once associated with the innocence of adolescence, were now linked to a gruesome rape and murder. The case against them was built on shaky grounds: high-pressure interviews without their parents or guardians present, confessions alleged to have been coerced, and evidence that was later found to be withheld. Yet, this was enough to seal their fate, sending them to prison for the better part of their lives. The Dixmoor Five were not just victims of a mistaken identity or a misinterpretation of the facts, they were casualties of a system that failed them. This unsettling story forces us to confront uncomfortable truths about our justice system and to question the price of a wrongful conviction. It compels us to think about the lives that are irreversibly damaged, the years stolen from innocent individuals, and the trust eroded in a system designed to protect and uphold justice.
And that right there, let's look at those words some more.
Of a wrongful conviction. It compels us to think about the lives that are irreversibly damaged, the years stolen from innocent individuals, and the trust eroded in a system designed to protect and uphold justice.
The lives damaged. So it's not just the individual who's wrongfully convicted that goes to prison. It's not just them, but it's their friends and family who grieve for missing that person, for that person. No, like, what if that was your child or your family member that was in prison for a crime that they didn't commit? You would be heartbroken and worn out. A lot of times, mothers are, it takes a toll on parents, especially mothers, if like a son goes to prison or something, and they often pass away early, like they have health issues. I've seen it in a lot of documentaries and things that I've watched where kids, parents whose mother, they're waiting their whole life for their son to get out and they know that their son's innocent, and it's so heartbreaking. It destroys so many lives. What was the other thing that he said? The years stolen from that individual that's in prison, they can never get those years back. Even if it's just months, you can't get that time back. I think about covering the Canton cover up, the Commonwealth of Massachusetts versus Karen Reid, and we talk about Turtle Boy. Also, Turtle Boy is a he's starting to become famous now, so I probably won't need to introduce him, but he is a YouTuber who um, has been covering this case. He's cracked a lot of news about this case that we didn't know, and he always comes with receipts. He's always um, forthright with what he's telling you. So, because of his effectiveness of shining the light on the corruption that was going in the town arrested him. The county arrested him. And he went uh, to jail for 60 days on bogus charges. And he lost that time with his kids. He's got little ones at home. He missed his birthday with them. He missed Christmas with them. Like New Year's, all of those things he didn't get to share with his kids, and it's just heartbreaking that the system, like the last point, the system that's supposed to be protecting us isn't. There are cases where the system that's put in place to protect us is actually the ones that are harming us, such as in Massachusetts. There's a whole lot of corruption with the cops, the police there. And it's everywhere. It's not just Massachusetts, it's everywhere. There's going to be corrupt people in every position. It just so happens that people in law enforcement or at the prosecution, the prosecutor's office, the district attorney's office, if I could think of words, if they're corrupt, if one of those people are corrupt or have shady morals, things like this can happen where Karen Reed is totally railroaded by the police, or in this case, five young individual boys who had nothing to do with this crime were coerced by law enforcement to give a confession.
Stolen from innocent
I'll
individuals,
stop there.
and the trust eroded in a system designed to protect and uphold justice. So, how did these innocent teenagers end up spending almost 2 decades behind bars for a crime they didn't commit? This question sets the stage for a journey into the harrowing tale of the Dixmoor Five, a journey that will reveal the disconcerting realities of wrongful convictions in our justice system. It began in 1991 in the small town of Dixmoor, Illinois. A quiet community was about to be shaken to its core, and 5 young lives were on the brink of being irrevocably altered. 5 teenagers, Jonathan Barr, James Harden, Robert Taylor, Robert Lee Veal, and Shane Sharp, all between the tender ages of 14 and 16, found themselves in the midst of a nightmare. They were arrested on charges of a heinous crime, the rape and murder of a 14-year-old girl, a crime that had left the town in shock and mourning. But the nightmare was far from over. The boys, still children in many ways, were plunged into a world of high-pressure interrogations.
They were children. They were 14 years old. That's a child. In my opinion, that is still a child.
A world far removed from the schoolyards and neighborhood streets they were familiar with. Imagine the scene, 5 frightened teenagers sitting in cold, harshly lit interrogation rooms. They were without the comforting presence of their parents or guardians, without anyone to guide them through the intricate and intimidating labyrinth of law enforcement procedures.
Think about that. At 14, being someone that is getting interrogated by law enforcement for committing homicide. And he does not have, none of them had parents or representation. And you know what? You can just say you want a lawyer. They will provide you one. And people don't even know this. You can just say, I want to speak to my lawyer and I need a lawyer. And they will give you a lawyer. You might get, you might have to wait a little while in a holding cell or something, but they will eventually get you a lawyer. And doesn't mean they're going to be a good lawyer, but you don't have to sit in an interrogation by yourself with law enforcement ever. Nope, nope. I recommend don't do it. If cops want to talk to you, don't do it. Get a lawyer, have a lawyer present.
The boys faced seasoned police officers who bore down on them with a fervor driven by a community's demand for justice. These interviews were not just intense, they were relentless, and the boys found themselves pushed to their limits. Under this immense pressure, 3 of them ended up confessing to the crime. But these were not simple admissions of guilt. Rather, they were coerced confessions, extracted under distressing circumstances that involved physical abuse and threats. One might wonder how such a thing could happen. How could innocent teenagers confess to a crime they did not commit? The answer lies in the intense fear and confusion that these high-pressure interviews incited. The boys were trapped in a situation they didn't fully understand, and they were desperate for a way out. In their naivety and fear, they saw confession as their only escape, not realizing the grave implications it held for their futures.
I also want to chime in here too that sometimes law enforcement will tell you you can go home if I get a confession out of you. If you tell, not in those words, but basically like, well, if you want to leave, you can leave anytime. I just, you need to tell me first what I'm asking. And that's how they'll manipulate anyone to children or adults. They try to manipulate you to get you to confess.
With the confessions in hand, the police had their suspects, and the justice system began its course. The 5 boys, now labeled as criminals, were about to be thrust into a trial that would decide their fates. Little did they know, their journey through the maze of injustice was just...
Pause. Okay, this is a cool courtroom. I know this is just like stock footage or whatever, but this is a cool looking courtroom. How old is that place? It's got to be real old.
Just beginning. The trial of the 5 young men, now known as the Dixmoor Five, was a spectacle that reverberated throughout the community. The courtroom was a battleground, rife with tension and uncertainty. Yet it was here that the 5 teenagers were tried and convicted for a heinous crime they did not commit. The prosecution's case hinged on the confessions obtained from the young men. These confessions, extracted under high-pressure situations, were presented as the main evidence against them.
God.
Despite their allegations of coercion...
I don't know if the cops did that, but I mean, if they are going to torture you, they might. That's some crazy stock footage.
And abuse during their interrogations, the confessions were accepted by the court. The case was further complicated when 2 of the 5, Veal and Sharp, struck plea deals. In exchange for 20-year sentences, they agreed to testify against their friends. This decision, made under duress, added another layer of credibility to the prosecution's case.
The other thing that they try to do to get you to confess is they'll say, hey, your buddy in the other room there, he told my partner that you guys did it. So you can tell us how it happened, or should I just trust him because he said you pulled the trigger? That type of manipulation goes on.
The trial was a flurry of accusations, testimonies, and legal arguments, but what stood out...
And of course, that's a lie. I mean, because they weren't guilty of anything. But obviously, cops will say that to try to get you to confess
Out was the lack of
and turn on one another. Sorry, sorry, sorry. They will try to get you to confess and turn on one another. I will shut my mouth now.
substantial evidence. No physical evidence linked the five to the crime, and the confessions bore the hallmarks of coercion. Yet the court was swayed by the narrative woven by the prosecution. The outcome? Harsh sentences that eclipsed the young men's lives. Hardin and Taylor, tried together, were sentenced to 80 years in prison. Barr tried separately.
80 years. 80. 80 years in prison. They're 14-year-olds.
Was sentenced to 85 years. Veal and Sharp, due to their plea deals, were handed 20-year sentences. In the end, the trial, marked by its lack of evidence and reliance on dubious confessions, resulted in the conviction of 5 innocent young men. The courtroom, once a symbol of justice and fairness, had become a place where their futures were stolen. Years started to pass, but the truth remained buried, and 5 innocent lives were being wasted behind bars. 20 years later, in 2011, new DNA technology unearthed a shocking truth. A truth that shook the very foundations of the justice system and gave a glimmer of hope to the 5 men, now adults, whose youth had been stolen by a system that had seemingly failed them. The DNA tests, a marvel of modern science, revealed a startling connection. The semen found on the victim, the fingerprint of a heinous crime, did not match any of the Dixmoor 5. Instead, it traced back to a man named Willie Randolph. Randolph, a convicted sex offender, was on parole at the time of the crime. He was a man unconnected to the Dixmoor 5, a chilling reminder of the miscarriage of justice that had taken place 2 decades earlier.
So in this, he says it was a fingerprint, but I have a source that says it was something else, and I will explain the story as well in my reading.
This revelation was a bolt from the blue, a twist of fate that exposed the cracks in the justice system. It cast a glaring spotlight on the failings of the past, the coerced confessions, the withheld evidence, the false testimonies. The Dixmoor 5, who had been painted as monsters, were vindicated by the very science that was supposed to have sealed their fate. But what did this mean for the Dixmoor 5? It was a bittersweet moment, a vindication that came 2 decades too late. The discovery brought a rush of emotions, relief, anger, and a burning desire for justice. The innocence of these men was no longer a question of if, but a proven fact. Yet, they were.
Think about everything that you've done in your life since you were 14 years old until you were 34 years old. And then take it away. That's what these boys had. Pretty much their whole teenage years and adult life were early adult life were taken from them. You can't get that back. You can't get back your date to the prom. You can't get back, graduation and your first real girlfriend and all those things. You can't get that back. They took that from them.
Were still behind bars, their lives forever altered by a crime they did not commit. This revelation wasn't just a turning point for the Dixmoor 5, it was a wake-up call for the justice system, the urgent need for reform. The discovery sparked debates about the reliability of confessions, the importance of DNA testing, and the need for checks and balances to prevent such miscarriages of justice in the future. The revelation also raised questions about the handling of the case by the police and the courts. Had there been a rush to judgment? Had the pressure to solve a high-profile crime led to the scapegoating of 5 innocent teenagers? These questions demanded answers, and the Dixmoor 5 were determined to seek them out. The innocence of the Dixmoor 5 was now undeniable, but the fight for justice was far from over. Their story was no longer just about them. It had become a symbol of the larger issue of wrongful convictions in America, a rallying cry for change. The Dixmoor 5 had a long road ahead, but they were ready to fight, armed with the truth and a determination to expose the failings of the system that had robbed them of their youth. Finally, in November 2011, the Dixmoor 5 tasted freedom once again. After spending almost 2 decades behind bars for a crime they did not commit, the men were finally released. The iron gates that had held them captive for 19 long years opened, and they walked out into a world that was vastly different from the one they had left behind. The convictions of the Dixmoor 5 were vacated after DNA evidence connected the crime to Willie Randolph, a convicted sex offender who had no connection to the men. This was a significant turning point in their lives, a moment that would mark the end of a long, arduous journey and the beginning of a new one. Being released from prison after such a long time must have been an overwhelming experience. Imagine the rush of emotions they must have felt: relief, joy, anger, and perhaps a sense of vindication. They had always maintained their innocence, and now, finally, the world knew they were telling the truth. But their ordeal was far from over. The emotional scars of their wrongful convictions ran deep, and they were determined to seek justice. They filed a federal lawsuit against the officers who had wrongfully convicted them, alleging that they had been coerced into giving false confessions and that evidence had been withheld. They were seeking accountability, compensation, and punitive damages for violation of due process, failure to intervene, conspiracy, malicious prosecution, and emotional distress. The lawsuit was a battle, a fight for justice that was both necessary and arduous. It was their way of reclaiming their lives, of standing up against the system that had wronged them so severely. It was also their way of shedding light on a criminal justice system, of making sure that their story was heard and that no one else would have to suffer the way they did. And their fight did not go unnoticed. In 2014, after years of legal battles, they reached a settlement with the state of Illinois. The Dixmoor Five were awarded $40 million, the largest wrongful conviction settlement in the state's history. This was a significant victory, not just for the Dixmoor Five, but for all those who had been wrongfully convicted. It was a statement, a message that the system had failed and the change was necessary. In 2014, they reached a $40 million settlement, marking the end of one chapter and the beginning of another. But their story is more than just a tale of justice served. It is a reminder of our criminal justice system, a call to action for reform, and a testament to the resilience of the human spirit in the face of adversity.
I just realized that I had my mic muted.
2014, they reached a 40. It was a statement.
$40 million. $40 million is what I was saying. A $40 million settlement. So thank you so much, Illinois, for screwing that up so badly, because that comes out of the taxpayers' money. And if it's your state where they are wrongfully convicting people, that's coming out of your pocket too. Disgusting. All right, so I'm gonna, so that was a little, um, a short video that I had found that briefly describes everybody, um, or it briefly describes this case, I should say. I can't do two things at once. Why do I try? Let me shrink myself. All right, so I'm going to read you from the Innocence Project the case of the Dixmoor Five, and then we're going to talk a little bit about how Illinois might um, be part of a reform for wrongful or coerced confessions. All right, so this is Robert Taylor. Let's go through their images first. So this is Robert Taylor. This is Jonathan Barr. Shane Sharp is the individual that looks like he's crying on the one on the far left bottom. And then next to him is going to be Robert Lee Veal. Okay, and then we've got here is James Harden. All right, so those are our Dixmoor Five. I'm going to read to you the story of the Dixmoor Five. So the crime, here's the crime. In the afternoon of November 1991, 14-year-old Cateresa Matthews left her great-grandmother's house in Dixmoor, Illinois, and was not seen again until December 8, 1999, so a couple weeks later, when her body was discovered on a well-worn path running along I-57 as it passes through Dixmoor. And I want to know, was she taken and held somewhere, or was she taken and the act was done? Her life was ended, and then they held onto her body for that long. Like, I'm confused as to why it's on a well-worn path. Like, they point that out. Was not seen again until December 8th, when her body was discovered on a well-worn path as it passes or along I-57 through Dixmoor. All right, so she had been shot in the mouth at close range with a .25 caliber pistol. She was also an obvious victim of SA, as her body was naked from the waist down. A pair of white panties was found near her right ankle, and her jeans were draped across her chest. Seminal fluid was recovered from her body. Here is the investigation. The police made no arrests and seemingly had no leads in the case for over 10 months, until October 20th, 1992. On that date, a police report indicated that someone named Keno Barnes, who was 15, allegedly informed the police that Jonathan Barr had told him that when he last saw Cateresa, she was getting into a car occupied by Robert Lee Veal and Robert Taylor. At the time of the crime, Barr, Veal, and Taylor were 14 years old. On October 29, 1992, police brought Veal, 15, in for questioning. After more than 5 hours in police custody where he was interrogated outside the presence of his parents or counsel, Veal signed a handwritten statement implicating himself, Jonathan Barr, Robert Taylor, Shane Sharp, and James Harden. So two of the individuals were 17 and two were 15, but I think this was at the time that they signed the confessions, so they were younger at the time of the crime. So they all signed a confession in the R and homicide of Cateresa Matthews. So later that day, Robert Taylor signed a handwritten statement, again outside the presence of his parents or counsel, implicating himself and the other four teenagers in the crime. So we've got now two handwritten statements, Veal and Robert Taylor. So whatever the cops are doing, they are doing it effectively enough to break these individuals down to give handwritten confessions. The Reid technique, as I've talked about, is very effective in getting a confession. It just means you could get a confession from an innocent person too, because anybody would want to confess when they've got the light in their face, the people in their face, screaming at them, yelling at them, uncomfortable, hot, have to go to the bathroom, hungry, all those things because they're depriving you of your basic needs. All right, so now we've got two handwritten confessions, and he implicated this last one, Robert Taylor, implicated himself and the other four teenagers in the crime. On October 31st, after more than 21 hours in police custody, 21 hours, Shane Sharp also signed a handwritten statement implicating himself and the other four teenagers in this crime. The three confessions contradicted each other on the basic facts of the case. So, now we have three handwritten confessions, but the facts don't match. Now you have a problem, police. But for whatever reason, they're still convicted. All right, in June 1994, before any of the teenagers were tried, the Illinois State Police Crime Lab identified a lone male DNA profile from the sample that they recovered from the victim's body. Even though all five defendants were excluded as the source of the sample, the prosecution pushed forward rather than seeking the source of the sample that they actually recovered from the victim's body. Now, trial and post-conviction. Based on doubts about the truthfulness of the confessions, a juvenile court judge refused to charge Barr and Taylor in adult criminal court, a decision later reversed by an appellate court. Beal and Sharp pled guilty to first-degree homicide and received 20-year sentences. That's the two that did made the deal. So they made the deal. They pled guilty to first-degree homicide and received 20 years with parole available after 7 in exchange for agreeing to testify against Taylor, Harden, and Barr, which means they didn't have enough evidence on those three. That's why they make a deal. This is the only reason why the state would make a deal. They need to get something out of it. All right, so over the next 2 years, all three were convicted. Taylor and Harden were both sentenced to 80 years, and Barr was sentenced to 85. Meaning, if he were to live that long, he'd be 99 years old by the time he gets out of prison, right? Is Barr 17, 14? I don't know, whatever. You get the drift. You get my, um, you catch my drift is what I was meaning to say. Where did I lost my spot now. All right, so 20 years for those guys. Over the next 2 years, all three were convicted. Taylor and Hardin got 80. Barr was sentenced to 85. All subsequent appeals were denied, including a post-conviction request for DNA testing. In August 2009, Hardin again sought DNA testing, a request later joined by Taylor and Barr. For more than a year, the Dixmoor Police Department claimed that it was unable to locate the DNA and was threatened with contempt of court for failing to respond to a subpoena. Like, why are you hanging on to it so much that you won't, that it's come to that point where the court has to tell you, hand it over? Eventually, Cook County Judge Michelle Simmons ordered the Dixmoor police to allow defense counsel to view the evidence storage areas and logbooks for themselves. Soon after that order, the department informed the lawyers that they had finally located the evidence. DNA testing uncovered a full male profile that was entered into the CODIS database of criminal offenders, and it matched the DNA profile of a violent serial offender, Willie Randolph. Oh, yeah, they have a match, but yet the boys, doesn't matter? No. At the time of the crime, Randolph was 33, lived in the victim's neighborhood, and was on parole after serving a 20-year sentence for armed robbery. He was apprehended by authorities April 12th, 2001. Based on the DNA evidence, Judge Simmons vacated the convictions of Taylor, Hardin, and Barr on November 3rd, 2011, and the state's attorney's office dismissed all charges against the five men. Taylor, Hardin, and Barr were released from prison. Veal had already served his prison term and was living in Minnesota. Sharp served 10 years in prison for the crime. But based on his presumed criminal history, he was sentenced to an additional 10 years. In 2009, for unrelated drug charges, he was released in February 2012. And then it lists all the people that represented these individuals: the Center for Wrongful Convictions, University of Chicago Law School Exoneration Project. Those are some, I don't know them, Stuart Channon of the Valorum Law Group, and Sharp. Don't know. But anyways, so that is the story of the Dixmoor Five. I'm just going to scroll up here. So we're going to look at their stats. Okay, so Robert Taylor, he served 14 years and he was sentenced to 80. And he was exonerated the 11th. I'm sorry, the 3rd of November 2011. He did not plead. We don't need this. Sometimes there's more interesting stats here. But anyway, so he served 14 out of his 80-year sentence. Jonathan Barr served 14 out of his 85-year sentence for the same crime. Shane Sharp, who, again, if you look at the thumbnail, he is the one at the far left bottom corner. He served 18 years of his 20-year sentence. So the people that made a deal had to serve more time? Is that fair? I don't know. Why was he served, or not served, but I don't know. And it doesn't say why why he was still in for 18 years while these individuals were in for longer. Robert Lee Veal, 16 years. Same thing. He had the 20-year sentence. So these were the two that made the deal. So again, on the thumbnail, it's the one next to, or it's the other one on the bottom. So the far left corner is, who did I say it was? Shane Sharp, and the other gentleman on the bottom is Robert Lee Veal. All right, so Robert Lee Veal, he served 16 out of his 20-year sentence. James Harden served 16 out of his 120-year sentence. So he got kidnapping and robbery on top of everything. Yeah. Okay. So finally, let's learn a little bit about how Illinois is going to maybe do a little reform. So, Illinois, this is an article on the Innocence Project website, and it has everything to do with the Dixmoor 5, and they're in it. All right. So, Illinois can once again lead in preventing wrongful convictions by passing a critical false confession bill. A new proposed Illinois legislation would allow judges to rule on whether or not a confession is reliable, a key reform to prevent wrongful convictions. And this is an op-ed by Peter Neufeld and Stephen Drizzen. Oh, Stephen Drizzen, he's the gentleman who represented Stephen Avery, I believe, in Illinois, right? I think so. Because he was from Northwestern Illinois, which formed the what's it called? I have to scroll to the bottom. They formed the University of Chicago Law School Exoneration Project, I believe. So him and the other woman who was representing, not Steve Avery, but Brendan Dassey. Sorry, Brendan Dassey. All right, so this is their op-ed, and it was just recently written on the 22nd of this month. All right, so Robert Taylor, Jonathan Barr, James Harden, Robert Lee Veal, and Shane Sharp, all known as the Dixmoor Five, were all between the ages of 14 and 16 when they were wrongfully accused of the 1991 and homicide of a young woman in Cook County, Illinois. Prosecutors argued that the confessions obtained from several of the young men were admissible because they were made voluntarily. The default test used by most courts to find voluntariness is whether the accused signed their Miranda warnings or their waiver, which these teenagers signed. However, the mere acknowledgement that you are aware of your rights, for example, the right to remain silent, even assuming a full import of the waiver was understood, doesn't provide the court with any assurance that the confession is reliable. Despite the fact that Illinois judges routinely rule on the reliability of other evidence, such as eyewitness identifications and forensic evidence, Illinois has not asked its judges to assess the reliability of the alleged confession. In the Dixmoor 5 case, given that the DNA evidence pre-trial excluded each of them as the source from the sample on the victim's body, and their so called confessions did not align with one another or the evidence, it is unlikely that a judge would have found the confessions reliable. So, wrongfully convicted, the Dixmoor 5 spent a total of 95 years total, accumulated total behind bars, losing years of their lives like I said, they can never get back those moments. Your first kiss, your first love, your first everything. You don't get those back. Enjoying them as a teenager and enjoying your life and being free and being a kid, you can't get those years back. I can only imagine how much damage and trauma that does to the individual who is locked away and always trying to hold out hope that they'll get out one day. So sad. All right, so wrongfully convicted, the Dixmoor 5 spent 95 years total until they were exonerated. Meanwhile, the real perpetrator, subsequently matched to a DNA database search, remained free and, in fact, committed other crimes. While, that's the other part of this is that when you don't put the right people away, the people that got away with it are going to do it again and again and again until they don't get away with it or until something happens to them and they're no longer here. All right, so anyway, so across the country, confessions that satisfy the voluntariness test can be admitted as evidence at trial, even if they are irrefutably false and unreliable, like those of the Dixmoor Five. In fact, attorneys of, for the Dixmoor Five moved to have their confessions thrown out, but were denied because the judge only considered voluntariness and not the confession's lack of reliability. Their case is just one of many demonstrating the need for a legal mechanism for judges to rule on whether a confession is reliable. And I agree that this is pretty big to allow, but you get biased judges too, so but it's another step. It's another set of eyes that's looking at it. So I appreciate that Illinois is doing this a lot. All right, so had this been in place and had their interrogations been recorded, it is likely the confessions would not have passed the test for admissibility, and the tragedy of their wrongful conviction might have been avoided. There is, I do want to point out, if you go to innocenceproject.org and search through the articles, it might even pop up on your article for the Dixmoor 5, and you'll see this. There's a link. If you click on that, you can sign a petition. And is there something else here? Let's do it. I usually have petitions. Yeah, so here's the whole thing. Here's the whole bill, which is about someone else, this Mr. Gonzalez or somebody. Call your See, I should find out who he is too, because it's Illinois. Illinois, shout out. All right, so legislators have a chance. Oh, wait, my whole point was to go here, enter your phone number, your details, and your whatever, and then you can sign the petition there. And then there's more information about the actual bill itself. All right, so legislators have a chance right now to make such a provision possible, and they should take it. Illinois is known as the wrongful conviction capital of the country. I did not know that. Where have I been? I need to get my button gear and look at these Illinois wrongful convictions. All right, so Illinois' 540 exonerations tops the ranking of states, followed by Texas at 474. Wow, so like we're way over. Illinois is also the false confession capital of the country. According to the National Registry of Exonerations, 135 of the 445 exonerations nationwide that involved false confessions happened in Illinois, a full 30%. That's despicable. Ugh. All right, so almost all of these exonerees filed motions to suppress their confessions before their trials, but because the judge merely tested voluntariness, all of these innocent people were convicted and spent decades in prison before they were cleared. And again, it's not just them and all the long-term effects it has on your complete psyche, but it's the family members that are missing those people and the people that are counting on that person for being there and support and whatnot. So, uh, and then the trust within the system fails. So there are some telltale signs that a confession may be false. False confessions often fail to lead police to new evidence and may even contradict other witness testimony or physical evidence, as was the case with the Dixmoor Five. However, as it stands, judges are powerless and cannot choose whether to exclude or admit a confession from evidence based on its unreliability. This has to change. Besides the obvious and terrible moral cost of these wrongful convictions, there is an economic cost to taxpayers not only in Illinois but in every state across the country. Exonerees are often and rightly awarded millions of dollars in civil suits, and even the cost of opposing these lawsuits can run up to $5 million per case. Representative Justin Slaughter, chairman of the Illinois House Judiciary Criminal Committee, blah, blah, has introduced legislation House Bill 5346 that would create a pre-trial mechanism for judges to consider the reliability of confession evidence and provide guidance to the hallmarks of an unreliable confession. Under the proposed legislation, a judge could refuse to allow a confession into evidence if, for example, the confession fails to provide any new details to law enforcement, doesn't line up with other evidence, or directly contradicts other evidence. Or you have a video of law enforcement directly in front of your eyes coercing the confession out of the kid, like in Dassey. So while Illinois has been a nationwide leader in wrongful confessions, the state has been a leader and innovator in solving the contributing problems of wrongful convictions. In 2021, Representative Slaughter and his chief co sponsor, Republican Minority Leader Jim Durkin, unanimously passed legislation to ban the use of law enforcement deception in the interrogation of minors. And that right there is huge. Minors can't tell if someone's lying. They can't tell if they should say something or not because they think it might, or they won't know if it incriminates them or not. So, yeah, that's great that Illinois is doing that. They're also doing it away with or they're doing a different kind of bail system where it's more representative of your income rather than, just some arbitrary number that a judge throws out there. All right. Anyway, so Slaughter, Republican, um, yeah, so they have banned the use of law enforcement deception in the interrogation of minors, a first in the nation bill that has led to bans in Oregon, California, Colorado, Connecticut, Delaware, Nevada, and Utah. That's seven. That's seven other states that followed suit. That's awesome. No more lying to minors in interrogations. And you know what? Why don't you just also make it that they can't do it when the minor is without an adult? All right. So Representative Slaughter's work follows in the footsteps of former Illinois State Senator and U.S. President Barack Obama, who passed the first law requiring the video recording of interrogations in the country, leading the way for 33 other states to enact similar policies. And I love that that law came into place because I think I am pro police wearing body cam 24/7 of their day. I don't care if it's boring, but I think that they need to, if they're not, having a moment to themselves in the bathroom or something, or, when they're in the bathroom or calling their wife for, to talk about plans for the night, you can turn it off. But when you're on duty and you are supposed to be the face of the county or town as someone who's in an authority position and is there to protect. So do it right. It just frustrates me. Right. Illinois could become the first state in the nation to ensure reliability in confessions by passing House Bill 5346 and serve as a beacon to all other states when it comes to keeping unreliable evidence from fact finders. Together with recording interrogations and banning police deception to minors, this trifecta of reforms would bring to fruition a vision set to 2 decades ago to prevent false confessions from ripening into harrowing and costly wrongful convictions. And that, my friends, is the end of this stream. So, what do you think? I definitely recommend you go to Innocence Project. I'll put a link in the comments below or in the description below for you to sign up and help us pass this bill in Illinois. Should I read through this? You guys want to know what the bill is? Let's listen to the bill. All right, so this is Call Your Illinois Lawmakers. urged them to pass this bill to become the first state in the country to protect innocent people from having unreliable confessions used in court. Angel Gonzalez was wrongfully convicted of a 1994 R in kidnapping and spent nearly 21 years in prison for a crime that he did not commit. 21 years. And he's a minor, right? So investigators quickly honed in on Mr. Gonzalez as a suspect after the victim's boyfriend noted that Mr. Gonzalez's car did not look like it belonged at the apartment building. Wait, what? At the time of the incident, Mr. Gonzalez spoke very limited English and was never told why he was arrested. By the time the interrogation began, Mr. Gonzalez had been awake for over 24 hours and he waived his Miranda rights, which were read to him in English. Mr. Gonzalez maintained his innocence and provided an alibi. However, the detectives lied and told him that those individuals did not support his story. Mr. Gonzalez was eventually interrogated in Spanish and was asked to write out a statement in Spanish. However, Mr. Gonzalez's written statement did not match the details of the crime, so one of the detectives prepared a written statement in English, which Mr. Gonzalez then signed. So many problems in that one paragraph with law enforcement right now. I can't even begin to unpack that right now. All right, so although no physical evidence ever linked Mr. Gonzalez to the crime and he had multiple witnesses to confirm his alibi, he was convicted based in large part due to the signed English confession that the detective had written. That's, it makes me sick to my stomach that they would do that. Mr. Gonzalez was convicted and sentenced to 55 years in prison for aggravated SA and aggravated kidnapping. When the Illinois Innocence Project took up Mr. Gonzalez's case in partnership with the Innocence Project, they were able to secure DNA testing on the crime scene and the R-kit evidence. The testing conclusively showed that Mr. Gonzalez was not one of the perpetrators and his conviction was finally vacated in 2015. Providing judges with a mechanism to assess the reliability of a defendant's statement before trial is a critical step in safeguarding against wrongful convictions. While Mr. Gonzalez was eventually exonerated due to DNA testing, his statement, along with many other Illinoisians whose convictions are based on unreliable statements made during police interrogations, should have never been used as evidence in court. And this is a campaign in partnership with the Illinois Innocence Project, Justice for All, and the Center on Wrongful Convictions. And again, I will remind you, please go there, fill it out, um, help us make a little bit of change in Illinois. That would be great if you could. All right, so I'm going to leave you guys just thinking on this note about going and filling that out and, make sure that you know what's going on in your county. Yeah, like I didn't even know that Illinois was a wrongful conviction capital of the country, and I live here. So, do some research into your own towns and see what your law enforcement's doing, what your prosecutors are up to. Keep an eye on them because that's how you are going to make change from the ground, the root up. You gotta cut out the bad from the bottom. I mean, let's start speaking our minds against law enforcement when we find that they're doing something wrong. Let's speak up and speak out against the DA's office when they're making charges happen to someone that they shouldn't be, like in the Karen Reid case. It makes me so patriotic to see how people get when I'm watching Tom CPU's stream and I see all the people in the streets and holding their signs and everything, and I'm just like, that's that's why this country is so great because we stand up for what's wrong. We stand up for the people that need a voice. And you might be that person that needs a voice, or you might be that person that could be a voice to others. So I will leave you with that note. So thank you guys so much for watching. I appreciate you so much. Please hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeandcourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.